Law students will sometimes hear or read passing references to legal formalism or formalist reasoning, and you'll often hear these terms juxtaposed against phrases like legal realism or instrumentalist interpretation. This video is an attempt to give a brief, general overview of the concepts associated with these terms without getting too deep in the weeds. Now, I say general because these are heavily contested terms about which an awful lot has been written, kind of like with any ism, and there's a lot of debate over the nuances. So one person's use of these terms may not match others. My goal here is just to give a feel for how these terms may be used, to give a sense of what someone means if they characterize a court as being formalist or instrumentalist. I'm not really here to argue in favor of any particular view. I should also say that this is not a video about any particular legal doctrine, but about broader questions about how judges do their job and how they should do their job. And hopefully I can get through this without getting the philosophers mad at me. So let's start with formalism in the law. At its most simple, legal formalism is the idea that law is a collection of legal rules that you find in constitutions, statutes, regulations, precedents, and so on, that judges should apply to the cases before them. And because we can study and understand these rules, we can look at what a judge is doing and be able to evaluate, at least most of the time, whether or not the judge has quote-unquote followed the law. On this view, to use the analogy made famous in the John Roberts confirmation hearings, a judge is just an umpire who calls balls and strikes.
Judges are like umpires. Umpires don't make the rules, they apply them. The role of an umpire and a judge is critical. They make sure everybody plays by the rules, but it is a limited role. Nobody ever went to a ball game to see the umpire.
So the umpire calls balls and strikes, but the strike zone is defined by rules external to the umpire's preferences. The pitch is either in the strike zone or not, and the fans can tell, or at least have meaningful arguments about, whether the ump got the call right or not. Of course, there are close calls, and one needs to do the work of understanding the rule in the first place. But given that legal questions are often a good deal more complicated than defining a strike zone, a lot of litigation is not just about applying the rules, but also defining their meaning in the first place. Typically, formalist arguments generally concern the meaning of legal rules and how they apply to particular cases. Now, that leaves something out. Questions about the meaning of legal rules are largely independent of outside considerations of whether the rule, or its application to a particular case, is good policy, or whether it leads to the best answer for society at large. That's the kind of question that would normally be for a legislature. Now, that doesn't necessarily mean that policy and values don't matter to a formalist judge. It's possible that the legal rule encompasses these considerations, and some legal rules may even open room for a judge to exercise independent discretion, that is, to do what they think is right within certain limits. And more broadly, one might believe that society works best, that we get the best results, policies, values, so forth, when courts focus on interpreting and applying legal materials while leaving policy or moral judgments to the legislature. Legal scholar Larry Solomon summarizes the core of legal formalism as encompassing these precepts. 1. The law consists, at least in part, of rules that are derived from the linguistic meaning or communicative content of authoritative legal texts. That is, we have places to go to learn the rules. 2. Legal rules can be applied to particular facts. In other words, these rules provide meaningful guidance on how to resolve cases within their scope. 3. Some actions accord with meaningful legal rules, other actions do not. That is, we're not just making stuff up as we go along. If we want to act lawfully, we are actually constrained by the rules. 4. The standard for what constitutes following a rule, or not, can be publicly knowable and the focus of intersubjective agreement. Stated another way, you and I may not agree on the right outcome to a dispute as a matter of policy, morality, convenience, fairness, or whatever. But we may still be able to agree that the law, insofar that we agree that we are bound by it, resolves the question independent of our personal preferences. To take a simple example, I might think that 30-year-olds should be allowed to run for president, but I don't dispute that the Constitution says that the age minimum is 35 years old, and I would agree that a judge who says otherwise is not following the law. Or, to take a famous hypothetical, suppose a statute says no vehicles in the park. We might disagree on whether cars should be allowed in the park, but we can agree that someone who drives their car through the park is breaking the law. And a court that deviates from this plain meaning to say otherwise is wrong, even if we think cars should be allowed in. Changing the law should be a question for the legislature. Note that we can use the word formalist in two ways to describe this outcome. We may say that the outcome was formalist as a descriptive matter, that the judge resolved the case by applying the statute without considering anything other than the statute's text. And we may argue that the formalist approach was, or was not, correct as a normative matter. That is, that the judge was right to resolve the case by looking to the rule and not by, say, considering the consequences of the car in the park. Okay, but this example is uninteresting if it's obvious that the rule applies to cars and there's no particular reason to allow them. After all, precision in language is difficult and it's hard to draft laws perfectly. What happens when we get to the harder case, when a strict application of a statute leads to harmful results? What happens if someone tries to apply the no vehicles rule to a war memorial that happens to be a decommissioned tank, or to an ambulance accessing the park in an emergency, or to baby strollers? Now things get more interesting. It's possible, if unlikely, that a judge will bite the bullet and say that a vehicle is a vehicle and ban the baby stroller. Sure, that would be an example of formalist reasoning, but there are plenty of ways to reach a different result while still claiming to be bound by the statute. Maybe the judge rules that, in context, the term vehicles is not plausibly understood as encompassing baby strollers. Maybe the judge will rely on interpretive rules and canons of construction that prevent absurd or unlikely results or require reasonable interpretation. Maybe past precedents are helpful. Or maybe the judge will read the provision in a way that harmonizes it with other rules, such as, say, a different rule that presumes the use of the park by babies and their parents, or, in the case of the war memorial, the statute authorizing the memorial. In other words, maybe a judge can prevent extreme results with formalist reasoning. Now, of course, some might argue about whether these are really formalist arguments, but let's leave that aside for now. But even if we agree that the judge could justify their decision with formalist logic, do we actually believe that those arguments really explain the ruling? Or should we understand the case as the judge's human reaction to the facts? There's no way the judge was going to forbid baby strollers, fine the ambulance, or tear down the war memorial, and that those reactions are not dictated by the legal rule, but by something else. And what's going on in a harder case, if the issue concerns something like bicycles or scooters? Are those cases decided by reference to legal materials, or are they decided by outside considerations? And how should they be decided? What happens if one reading of the legal materials looks more plausible, but would also cause serious harm? This brings us to legal realism. Now, legal realism is both a way to look at the law, but also a description of a movement in legal thinking in the first half of the 20th century that challenged strong formalist views on law and judging, what realist thinkers sometimes derided as mechanical jurisprudence. The legal realists argued that accounts of the law that focus on legal materials are incomplete. As Oliver Wendell Holmes, who some see as a realist and others see as a forerunner of the movement, wrote, "The life of the law has not been logic, it has been experience. Law develops based on the demands of the moment, prevalent moral and political theories, public policy intuitions, and prejudices. Those all matter more than deductive reasoning about the law in the books to telling us what the law actually is." This means that a lot of law, especially the kind of law that gets litigated at the appellate level and makes its way into law school casebooks, is actually largely indeterminate. Statutory text is ambiguous. Legal concepts lack definitive meanings. Past precedents can be distinguished, and interpretive rules, what lawyers call canons of construction, may be inconsistent. In hard cases, therefore, the legal realist argues that outcomes don't depend on the law. They rest on how judges respond to the facts of the case, and these reactions are guided by external, extra-legal considerations. Maybe a court will rule that no vehicles in the park includes bicycles, maybe not. But something other than the meaning of the word vehicle, past precedents about motorcycles, or canons of construction will answer the question. Courts will be motivated by matters beyond legal materials for their decisions. And note that you can believe the realist account without believing that judges are acting in bad faith. So, How should we respond to the indeterminacy of the law? One possibility is that we should simply just try to understand what is actually motivating case outcomes. Returning to Holmes, he famously wrote that for those subject to the legal system, law is nothing more than a prediction of what is going to happen if they do a certain act or not. So maybe we can't say whether a bicycle is a vehicle for purposes of our park statute, but maybe we can predict what a court will say based on patterns in the case law, politics, social trends, news events, the psychology of judges, and so on and so on. And for many realist thinkers, the point is that the resulting predictions are useful or not without regard of what we may think a vehicle is. Likewise, we can describe the results of a case in a similar way. Why did the court do that? What are the consequences? Etc. So this is largely a descriptive account. And of course, there are nice questions about how accurate particular visions of realism are with respect to particular opinions. Was the court simply applying the law, or was it actually motivated by outside considerations, or often a mix of the two? Likewise, saying that some law is indeterminate doesn't tell us how often that is the case. But, assuming there is a lot of indeterminacy in the law, what should judges do? What should someone with a strong realist perspective about the law want judges to do? This takes us to instrumentalism. Again, staying at a high level of generality, and instrumentalism is a term that has a lot of meaning in a variety of fields. An instrumentalist argument sees the law as a means of achieving some goal. So a court should consider the consequences of its choice in light of things like the purpose of the rule, or more general matters of social welfare, public policy, or shared values. Like formalism, instrumentalist approaches generate objections. Those objecting to instrumentalist arguments point to concerns of legitimacy, transparency, predictability, and competence. Note that some of these objections echo concerns with strong forms of formalism insofar as they concern the determinacy or not of the law. So, depending on the context, a realist objection to a formalist argument may be that the formalist claim hides the indeterminacy of the legal rule and therefore conceals the real basis of the ruling, thereby unshackling the judge to decide the case on other, less legitimate grounds. But a formalist objection to the instrumentalist argument may be that the instrumentalist claim undermines the determinacy of the legal rule and therefore empowers the judge to go outside the rule when they would not have been otherwise, thereby unshackling the judge to decide the case on other, less legitimate grounds. In other words, both perspectives have been attacked for leading to inappropriate behavior by judges. Clearly, then, a lot depends on the degree to which legal rules are really indeterminate, and people may have very different answers to that question. Are we talking about a coin flip? How often does that happen? Okay, maybe we're not sure about what the meaning of the rule is, but what if one reading is better, assuming we even know what that means? And let's even imagine that we can put percentages on our certainty. Where is the border between an indeterminate rule and sufficient certainty? When we're 51% confident, 55%, 60%, 90%? Or do we use outside considerations to determine how confident we are in the first place? In this regard, do the stakes matter? So say we're 55% sure that the no vehicles rule allows scooters. Let them in, right? But what if there have been accidents between scooters and pedestrians? What if there's been an injury, a death? And if statutory purpose matters, can we look outside the statute for evidence? What kind of evidence is appropriate? Conflicts between formalist and instrumentalist approaches quickly get us into debates about methods of statutory interpretation and attendant debates about textualism, statutory purpose, and legislative history. What about the argument that instrumentalist judging makes the law unpredictable, delegitimizing it in the eyes of the public? One response is, compared to what? Recall that the realist challenge to formalist approaches to judging is whether they are actually predictable and honest in practice. Maybe courts are more disciplined if they try to interpret a statute according to its purpose, and people debate about that, both as to whether such a move is normatively acceptable and as to whether it actually offers greater certainty than looking to legal materials alone. Another response is that if the goal is to promote, say, good public policy, then that goal includes the need for law that is stable, predictable, and legitimate. And that goal may mean that an instrumentalist argument will often rely on legal materials in the same way that its formalist counterpart would, particularly if doing so conforms to public expectations. In other words, instrumentalist and formalist perspectives may end up in the same or similar places a decent amount of the time. Formalist arguments have ways to avoid extreme results, and instrumentalist arguments have ways of avoiding unchecked judicial discretion. Now, of course, that's not to say we don't get extreme results from time to time, but there's reason to expect, or at least hope, that those aren't the norm. Given that, sometimes there is less of these debates than meets the eye, and when push comes to shove, I doubt many people believe in extreme versions of formalist, realist, or instrumentalist views of judging. I think most people, whether they think about it or not, are on various continuums between the extremes. Most everyone agrees that legal materials matter. Indeed, most approaches to judging start there.
There's that classic phrase that we're all realists now. Well, I think we're all textualists now.
And most everyone agrees that consequences matter. Though there are, of course, judges who purport to follow a purely formalist methodology, leading, of course, to nice debates and critiques from realists who question and argue about whether or not that's really the case. And a lot of those debates tend to get subsumed into broader debates about the Supreme Court. But whatever the balance, instrumentalist and formalist arguments are both alive and well in legal practice. That's not to say that debates about formalism, realism, and instrumentalism don't matter, and judges really do vary significantly on when and whether matters outside the legal rule will be used to resolve particular cases. Obviously, there's a lot to argue about what judges do, about the methodologies they use, whether they apply those methodologies correctly or honestly, and whether something other than legal reasoning explains their outcomes. Having a feel for debates about formalism, realism, and instrumentalism may be helpful to clarifying exactly what you think is going on in the cases that you read and how you think courts should be behaving. So if you think a court got it wrong, or worse, was behaving badly, it may be useful to clarify what you think is going on. Is the judge you're objecting to taking the right approach but getting the wrong outcome? Or did they get the wrong outcome because they took the wrong approach? Or did they get the wrong outcome in a way that conceals the quote-unquote real reason for their decision? And from your perspective, it's worth asking yourself if you're making those judgments from a baseline of how you think the law ought to operate independent of the particular case, or if your focus is more the specific consequences of this particular result. In any case, thanks for watching.